Welcome to Sharing with Myhanh, Understanding Together, Finding Peace Forever. In the last video, we talked about who really inherits an IRA and 401k, a topic that many families care deeply about. Today, I'd like to share another piece that is just as important. What role do a will and trust play in inherit an IRA and 401k? Many people assume that as long as we have will or a trust, our assets will automatically go where they want. But is that really the case? Let's find out together. Before we get into today's topic, let's take a moment to review some highlights from our last video. When it comes to IRAs and 401ks, the most important document is the beneficiary form. This is what truly decides who inherits the account. Under the Secure Act, a retirement law passed in 2019 that's changed the rules for inherited accounts. If the beneficiary is not a spouse, most of them must withdraw all the funds within 10 years. If there is no valid beneficiary listed, then 5 years rule applies, which means the entire account must be distributed within 5 years. For 401k plans, the ERISA law, a federal law passed in 1974 to protect employees' retirement benefits, gives the legal spouse first rights unless the spouse signs a waiver. When it comes to wills or trusts, many people think those documents can override the beneficiary designation, but in reality, they do not automatically apply to IRAs and 401ks. Those are the main takeaways from the last video. And today, we're going to go deeper into the role of wills and trust. Many people think that simply write a will is enough to divide an IRA and 401k. But in reality, this is not the case. For those accounts, the beneficiary form is always the most important. If the form lists someone's name, that person will inherit regardless of what is written in the will. The will only applies when there is no valid beneficiary, meaning the account falls into the estate. In that situation, the assets must go through probate and also subject to the 5 years rule. If there is a will, probate will distribute the assets according to the instructions. If there is no will, probate will distribute according to the state's default intestacy laws, usually prioritizing the spouse and children first, followed by parents and siblings. Many people mistakenly believe that once you set up a trust, then all assets, including IRA and 401k, will automatically be placed into the trust. But in reality, that's not how it works. For retirement accounts, such as IRA or 401k, a trust is only effective if it meets 2 conditions. First, the trust must be listed directly on the beneficiary form. That means when filling out the form, instead of writing the names of your children, you write the exact trust name. Second, the trust must meet IRS standards, often called a see-through trust. If it does not, the assets could lose tax advantages and be forced into faster withdrawals. So how do you properly list a trust on the beneficiary form? When you establish a trust, such as a living trust or revocable trust, the very first page of the trust document will show the full trust name and the date it was created. For example, the Trend Family Revocable Living Trust dated January 5th, 2022.
when filling out the beneficiary form, you must copy that name exactly word by word, including the date. If you simply write Trend Family Trust, the IRS or 401k custodian may reject it or consider it invalid. If both conditions are satisfied, then upon the account owner's death, the IRA or 401k transfers directly into the trust. The trustee will then manage and distribute the funds accordingly to the terms set forth in the trust. The important lesson: creating a trust alone is not enough. You must also list the exact trust name on the beneficiary form and ensure the trust is drafted properly. Only then can your family maintain control and take full advantage of tax benefits. A trust can be designated as a beneficiary on behalf of an individual. This is useful if you want to control how your assets are distributed. For example, if your children are young and not yet adults, or if you want them to receive the fund in stages rather than all at once. The advantages of a trust are: first, protects your assets from debt, divorce, or spending. Second, you can set withdrawal conditions such as using them only for tuition or receiving a portion each year. Third, this is useful for protecting minor children or several beneficiaries, such as people with disabilities. But for a trust to be recognized by the IRS, it must qualify as see-through trust. That means it is illegal under state law. When the account owner dies, the trust must become irrevocable. The ultimate beneficiary must be clear and an individual, not an organization. And especially, the trust name must be written 100% accurately on the beneficiary form, exactly as the trust document. A single wrong word can be considered invalid. If the trust meets the standards, the beneficiary is subject to 10 years rule or stretch IRA if it is an exception. If the trust does not meet the standards, the entire IRA 401k fall under 5 years rule. Force the withdrawal all within 5 years. The disadvantages of trust are: the procedure is more complicated. The trust needs to be prepared by an attorney specializing in estate planning. And if not written correctly, the family might lose the tax advantages that should be enjoyed. So, in summary, trust is powerful to protect and control access, but just setting up a trust is not enough. It must be set up accordingly to the law and filled out accurately on the beneficiary form to be fully effective. So now I will share some real examples for everyone to visualize. Case 1. Suppose Mr. A established a trust and clearly stated that divide all IRA or 401k accounts equally for the children, but he forgot to fill out the beneficiary form. With IRA, if the beneficiary form is left blank, this account does not automatically go into the trust. Instead, it falls into the estate and must go through the probate court to divide. The trust will not be effective unless the trust itself is clearly named in the form. With 401k, it is different because according to the federal law, ERISA, Employee Retirement Income Security Act, the current spouse is always the primary beneficiary by default. If there is no spouse waiver, That is a document signed by the spouse giving up his or her rights. Then when Mr. A died, the wife will still receive 100%, regardless of what is written in the trust. So the final result is the wife receives everything and the trust has absolutely no control. Case number 2. No beneficiary form, only will. Suppose Mr. B has an IRA and a 401k account. Mr. B does not fill out the beneficiary form, but only writes a will, which clearly states divide to 2 children equally. What about the IRA? Because there is no beneficiary form, the account will fall into the estate. The court must open a probate procedure to divide. If there is will, it will be divided according to the will, meaning the 2 children will still receive it, but it will take a long time and cost more in attorney fees and court fees. If there is no will, the assets would be divided according to the state law. Usually, the spouse is a given priority, then the children, then the parents or siblings. With a 401k, it is different. 401k is subject to ERISA, so the current spouse is always the beneficiary by default. If Mr. B's wife is still alive and has not yet signed the waiver to give up her rights, then the entire 401k will go to his wife, even if the will says it will go to the children. If his wife passes away, the 401k will fall into the estate and will only divide it according to the will or state inheritance laws. So look back. With an IRA, the children can still receive it, but it has to go through probate, which is time-consuming and expensive. With 401k, his legal wife will receive the entire amount, and the will has almost no effect. Case number 3 is slightly different situation from the previous examples. The owner of the account has a beneficiary form, and in the beneficiary form, primary beneficiary is the ex-wife, and contingent beneficiary is written as divided equally among children. The account owner also have trust, and in the trust, put primary beneficiary is divided equally among children, and the contingent beneficiary is to spouse. With IRAs, beneficiary forms is always first priority. In this case, beneficiary forms are always first priority. This means that in this case, the ex-spouse will be the recipient since they are listed as a primary beneficiary. If the ex-spouse dies before the account holder dies, the children, the contingent beneficiary, will receive. The trusts are worthless in this situation. With 401ks, they are governed by federal law ERISA. Under this law, if the current spouse is still alive, they are always the primary beneficiary by default, regardless of what the form says. That means the legal spouse will receive 100%. Only when the current legal spouse has signed a waiver or has died before the account owner, that is when the custodians go to the form, and at that point, the ex-spouse listed there could receive the money. So in summary for the case number 3, with the IRA, beneficiary form win the trust. The ex-wife received the fund. The trust is completely worthless. With 401k, if the current spouse is still alive and has not signed a waiver, the spouse receives the entire amount. If the spouse is deceased or has a waiver, the distribution is according to the beneficiary form. Let's talk about case number 4. I have a situation where the trust is recorded directly on the beneficiary form. For example, Miss B has $300,000 in his IRA. On the beneficiary form, he writes the Trent Family's Revocable Living Trust dated January 5th, 2022. The trust provision divide equally among 3 children when each reaches age 30. When Mr. B passes away, the IRA management company only looks at the beneficiary form because the form names the trust. The entire $300,000 will go directly to the trust. Then the trustee, that is the person managing the trust, will hold and distribute the money according to the terms of the trust. In this case, it is only divide among 3 children when each reaches age 30. But there is an important note. Not all trusts are valid with IRS. Suppose the trust states, after Mr. B passed away, all IRA money is kept in the trust. Only annual interest is paid to his wife, and the principal is left to future children. It sounds reasonable, right? But in reality, this is not valid according to the IRS standards because the ultimate beneficiary is not specially identified. Here it says future children, which can be future children, grandchildren, and great-grandchildren. The IRS does not allow ambiguous cases. The IRS requires all ultimate beneficiaries to be individuals who can identify at the time of the owner's death. When the life expectancies of the specific individual cannot be determined as a basis for calculation, the IRS does not consider this is a see-through trust. The result is that the trust will be treated by the IRS as an estate, forced to apply the 5 years rule. That means the entire IRA must be withdrawn within 5 years, pay taxes immediately, and completely lose the tax deferral advantage. So a trust can be a great tool to control and protect assets, but it must be set up according to IRS standards. Otherwise, instead of helping, it will add to the family's tax burden. Case number 5. 401k with trust as beneficiary. Here is an example. Mr. B has $300,000 in his 401k. On the beneficiary form, he names the trust, the Trent Family Revocable Living Trust, dated January 5th, 2022. And the trust has a provision that divide equally among the 3 children when each reaches age 30. But with 401k, it's different from the IRA because it's subject to ERISA, a federal law that protects a retirement benefits. Under this law, the legal spouse is always the primary beneficiary by default. That means if Mr. B is still married, even though the beneficiary form says it's a trust, the 401k management company must still pay the entire amount to his wife unless she agrees to sign a spousal waiver. If the wife agrees to sign the waiver, the trust will become effective. At that point, the entire $300,000 will be transferred to the trust, and the trustee, the trust manager, will hold the money and then divide it among the 3 children according to the terms, for example, only when the children turn 30 years old. Regarding taxes, the IRS also has its own rules. If the trust is written correctly, see-through trust, the IRS consider the children as the final beneficiaries, must withdraw all within 10 years, according to the Secure Act. If the trust is not written correctly, not see-through trust, the IRS considers it as an estate, must withdraw all within 5 years, or continue according Mr. B short RMD schedule. This is often more disadvantageous in terms of taxes. In summary, if there is no waiver, the wife receives all, regardless of what the beneficiary form says. If there is a waiver, the trust is valid. The money goes into the trust, divided among the children according to the terms. If the trust is not written correctly, the IRS considers it an estate, must withdraw fast, higher taxes. Here are a few key points to keep in mind when talking about inherited IRA and 401k. First, the Secure Act is a huge change. It tightens the rule for non-spouses. Most must be withdrawn within 10 years. But there is exception for children under 21, disabled, or chronically ill, and spouses has more flexibility. Number 2, the beneficiary form is always more important than the will or trust. No matter how you write it in the will or trust, if the form is different, the form is still number 1. Third, the will only applies when the account falls into the estate, meaning there is no eligible beneficiaries. At that point, it is brought to the probate court for division. Fourth, the trust only works if it is clearly stated in the beneficiary form. Otherwise, it's only applied indirectly through the will or estate. Number 5, if you are the current spouse, you actually have more options than anyone else. You can roll the account into your own IRA. You can keep it as an inherited IRA, or you can even delay taking required minimum distributions, RMDs. That flexibility is something only a spouse gets. 6, if you are non-spouse, for example, unadult children, sibling, or friends, you are almost subject to the 10 years rule, with some exceptions such as children under 21 years old, disabled person, or chronically ill person. The last one, the trust can also help protect and control the distribution of the assets, but it must be set up according to the IRS standards, often called a see-through trust, or you will lose the benefits. So, in short, form is number 1. Spouse has more options. Non-spouses mostly follow the 10 years rule. Trusts are useful but must be done correctly.
Thank you so much for watching today's session. I hope the information I share helped you better understand inherit IRA 401k, will and trust, and how to protect your assets for your loved ones. If you find the video useful, remember to like, subscribe, and turn on the notification bell so you don't miss the next video. And if you have any questions, please email to thumbandwealthhealth@gmail.com or contact me directly at 408-513-7350. See you in the next video of sharing with Myhanh, Understand Together, Finding Peace Forever. Wishing you and your family peace, health, and happiness.